Recording should have started, and it looks like I've also ticked something that says transcript, but sorry. Here we go. All right, so welcome to the people who've just joined while we've been talking. You might see that in the chat people have put in what language or languages they work in, they interpret in, and the yes or no is if you work for legal aid. So please feel free to add that to the chat too. So what we will cover is a little bit about legal aid. Some of you who work for legal aid might know a bit already, so I'll talk a tiny bit about legal aid. Then we're going to talk about words that we use. So it's not, everything about criminal law. It's specifically to help you know what all the words are that are used in the criminal law. So we'll talk about common words in court, criminal process words, legal document words, and just general words used in criminal law, as well as going into some of the offences that you might come across if you work in courts, and the sentences as well, which you would also hear if you work in court, and also where to get more help with legal words. Thanks, Tinsia. So just briefly about legal aid. So we provide quite a few different services. So there's firstly our call centre, which is called LawAccess New South Wales, and we promote that really as the first point of call for any legal help in New South Wales. And so you might be asked to interpret on calls to LawAccess. So that's we call that legal information. So anyone in New South Wales can access legal information from LawAccess New South Wales. Then the next step would be if someone is eligible, or if it's about a particular topic we can help with, people might be eligible for free legal advice. So we use the word information is more general and advice is specific to their situation. So legal advice is given by a lawyer. So we can provide free legal advice. Sometimes that could be at court. So the duty services at court is people can turn up on the day and see a legal aid lawyer, whether that's for a criminal matter or their domestic violence matter, like an AVO duty service. Family law also has duty services at court. So you might be asked to interpret for someone who's at court, so speaking to a lawyer or then going into court for a mention, which we'll go into soon. Minor assistance is just we can do like a small amount of work for someone. So fill in an application for victims support payments, or write a letter to a bank or something like that. So it's minor assistance, so a small amount of work. And then further down, so we often get asked questions about who's eligible for legal aid, or who can get legal aid, and it very much depends on the type of matter as well as whether someone's eligible. So we call that the means, so how much money they own or they earn, and also merit test, which is about the type of case. So that's a grant of legal aid, you might hear. All right, and we also do community legal education, which is like what we're doing today. So that's what my team does. So I'll just show you very quickly. This is a fairly new website that started last year, and maybe there might be some of the languages. So for some of your languages, you can get the site translated. So I've just highlighted that. If you go to legalaid.nsw.gov.au, you can see. Hello. All right. So that's a really good website. It has heaps of information on it. It's a really good first step to look up any sort of legal information. And there's also a section called Legal Words on the website, which has some explanations of some of the words we'll be talking about today. So that's just somewhere to look on the Legal Aid website. And I just wanted to briefly point out, so this is from an annual report last year, I think. So this is how many of our clients required an interpreter. so 3.6%. So yeah, it is quite a number. We speak to a lot of people, so it is quite a lot of people who need help from an interpreter. So I guess that's why we're doing these talks today. So thank you very much for your interest and for coming along. All right, well, that is enough from me for the moment. I am going to hand over to Helen now to get started into our criminal law words. And please ask questions. This is such a great opportunity, I think, for all of us to have Helen in our virtual room today. It's not that often, if Helen's at court, she doesn't have time to answer all these, questions you might have about the words. So this is our opportunity to have a very experienced lawyer in the room and hear from Helen and ask her questions. So thank you very much, Helen. Over to you to talk about criminal law words.
Hi, everyone. So my name's Helen, and I've been working at Legal Aid for a long time now, and I specialise in criminal law. I don't do family law or civil law. We do work with a lot of interpreters, and I really enjoy working with interpreters. And I just wanted to say that the job that you do, whether it's interpreting or translating documents between languages, is extremely important, because it enables me to communicate with my clients, or for my clients to communicate with me. And it also allows people to get their story across in court as well. So thank you for the job that you do. It's an extremely important job, and it's a job that I really respect, and I also enjoy simply listening to the different languages. And I like languages myself. Come from a mixed ethnic background, and also dabble in different languages sometimes. So I enjoy studying languages. So this is this is something that I really enjoy presenting, and some of you may have been involved in one of my cases, or in the future, if you're at Legal Aid interpreting in one of my conferences, or if you're at court for one of my clients, or you see me, please come and say hello. It's always nice to bump into people who have watched one of these sessions, and somebody recognizes me at court and says, hey, I'll listen to this session. So come and approach me. And if you do have a question, you can email us as well. Like if there's something specific that you want in addition, you can give some feedback and you can ask questions. So now I'll get into the presentation part of it. Every charge starts in the local court in criminal law. Doesn't matter how serious the charge is, it always starts in the local court. And some charges will finish in the local court, but other charges are considered too serious to finish in the local court, and they will go to district court. Or if it's murder or terrorism, or a big tax fraud allegation, it will go to Supreme Court of New South Wales. And then if somebody is appealing a conviction, they've been found guilty and they're appealing conviction, or they're appealing the length of the sentence that they got, then they might have to go to the Court of Criminal Appeal, which is in front of 3 judges deciding on the merits of that appeal. And the highest court in the whole country is the High Court of Australia, and it's very hard to have an appeal heard in that court. There needs to be special permission or special leave. That court does not deal with many cases per year, and they deal with cases of all types of topics, commercial law, criminal law, family law, from across the country. So that's the hierarchy of courts in New South Wales, from local court right up to High Court. The criminal process starts with when somebody is arrested by police. They are taken to the police station, And you might, as an interpreter, be called on the telephone or asked to come down to the police station because somebody requires an interpreter. So some of you may have attended a police station and you might be asked to translate a document or read somebody's rights to them, their right to a lawyer, their right to silence. So police have a sheet, a document, and you might have to interpret or translate that document to the person on the phone or in person about their rights at the police station. Very important. That's very important that the person understands that they have a right to silence, or that some people have a right to have a support person present at court. So that might be your first contact with the criminal justice system, the police station. Other times you might be asked to interpret phone calls that have been intercepted by police, text messages and things like that. So there's various roles that the interpreters are brought into at various stages in the criminal law proceedings. Then somebody might be charged by police after they've been arrested. They might be charged with some crimes. The police can then decide whether they give the person bail after charging them or refuse the person bail after charging them. And if police give the person bail from the police station, the person will be given a date to appear in court at a later date. If the police refuse bail, then the person will have to be brought to the court either that same day or the very next day. And as an interpreter, you might be asked by the court to attend court to interpret for this person who's been brought by police to the courthouse. So the court would have ordered an interpreter of a particular language, and that might be you, and you have to interpret, maybe you have to interpret in the person's bail application at the courthouse. You may have to interpret while that person speaks to a lawyer, and it could be a lawyer from Legal Aid at the courthouse before the person makes a bail application. So you may have to interpret during the conference with the lawyer. The court can choose to give the person bail or refuse bail. If they refuse bail, they stay in jail at least until the next court date. Then documents are given by police. Police produce statements, various forms of evidence, and the lawyers talk to their clients. And again, you might be asked to interpret in a conference with a client at the office or by video link or by telephone. And the lawyer will be giving the person advice and asking the person their side of the story. Then the person has to decide, what are they going to do? Are they going to plead guilty or not guilty? And then they go to court and tell the court what they are going to do about the charge. And if they plead not guilty, then if it's going to district court or Supreme Court, they'll go to trial. If they're pleading guilty, then they go to sentence, and a person can be sentenced in the local court, the district court, or the Supreme Court. And if they plead not guilty in a matter which is staying in the local court, we'll get to some sorts of matters soon, but it might be a goods in custody case, or it might be a break and enter case. It might be assault, a common assault charge, and they might stay in the local court in front of a magistrate and have the police prosecutors prosecute them. That would be a local court hearing. And district court or Supreme Court are called trial, and there's often the jury of 12 people with a judge. But we'll talk a bit more about that soon. So the role of police is to investigate information, investigate allegations, present evidence. They're not meant to just present evidence which tries to prove guilt. They're also meant to present any evidence which also may show that a person is actually not guilty of that offence, which, presenting evidence on a telephone, presenting statements made by various witnesses, which may actually show that the person is not actually responsible for the alleged crime. So police are just meant to present the evidence, and one way or another, it may or may not prove the guilt of the accused. They're not meant to hide any evidence which may actually help an accused. The lawyer is the lawyer for the accused person is representing that person's best interests, but they have an obligation to the court, and really you're trying to get the person a fair result, whether they're pleading guilty or not guilty. You're trying to get them the best result, but ensure that the whole process is fair as well. And the role of the interpreter is very important in facilitating communication between police and accused person, between lawyer and the client, and between client or the accused and the court. Or witnesses in court may need an interpreter, and an interpreter may be required to translate documents or interpret in court when somebody is speaking. So it may not just be an accused person, it might be a victim of crime as well, that you are required to interpret while that person's making a statement to police or while that person is giving an interview to police. Persons in New South Wales have a right to silence, and that's one of the rights that the police have to explain to a person, that they do not have to talk to police, that they have a right to silence, but anything that they say will be recorded and may be used in evidence. There's a special caution where a person does have a lawyer attend the police station. They are told that because they've got their lawyer there, that if they decide to not talk, but later decide to use something in their defense, that, that might not be admissible, because unless they've raised it now with the police. So it's a special caution which kicks in, so to speak, if the lawyer is sitting with them at the police station. And if anyone likes watching British crime shows, they have that special caution in their warning to people about anything you say may be used against you, and anything that you don't say now, you may not be able to rely on that later if you try to, if you've got the lawyer present with you. So the British warning is a bit different to the American warning. If you watch American crime show, if you listen to what they say to people at the police station or when they're arresting people, is a bit different to what the British say when they're arresting people. It's interesting, slightly different caution. Then we have what's called an ERISP, which stands for, it's an acronym, which stands for Electronic Record of Interview with Suspected Person, ERISP. So that is a video and a transcript of the interview between police and an accused person, and that becomes evidence in court if the person chooses to participate in that interview, which they don't have to, but if they do, then that becomes evidence. Questions and answers are video recorded. And one of the reasons that things started to become video recorded is because in the past, it wasn't as early back or as the 1980s, not everything was always video recorded. It kind of protects police against allegations of brutality and bashing people to get confessions, but it also protects the accused of being accused of something they actually did not say. So to protect everybody, things are video and audio recorded. Another name for that is record of interview. So ROI, record of interview. It's essentially the same as the electronic recorded interview with the suspected person. COPS stands for Computerised Operational Policing System, and that's a system used by police. They type into their computer system notes of an investigation, and every investigation, whether a charge is laid or not, every time police go to a house or go to a site and speak to people possibly about something that may have occurred, they create what's called an event number, or everything's given a reference number, and there'll be a record, a computerized typed record of police attending, or a 000 call has been made, and speaking to different witnesses, and some notes about that being called to a particular place, notes about witnesses spoken to, an investigation. In the local court, you will frequently hear H number. So if you go to the local court and you're interpreting there, you will frequently hear the magistrate, police prosecutors, and the lawyers speak about H number. And what that is a reference number that police create for every arrest, for every set of charges. So I don't know why it's an H number. I don't know why it starts with H. It just does, but it will have a capital H and have a series of numbers. So it might be H7931258. And some people are charged or arrested multiple times, and they may have multiple fact sheets, multiple arrests, and multiple sets of charges. So when they're in court with 3 separate arrests, 3 separate sets of charges, the magistrate will have a look at the H number and might tell the lawyers H number ending with the numbers 398. So everybody grabs their paper and has a look at which set of charges the magistrate is now talking about. That's just a quick way to make sure everybody's looking at the same set of charges. So it's a reference number that the police create, and it's on the top right-hand corner of the police fact sheet. So it's H number. That's what they're talking about when you hear that in court. Sequence, again, in the local court, you will hear this all the time. Person might say, pleading guilty to sequence 3, and the prosecutor might say, we're withdrawing sequence 5. So you'll hear this all the time, and you might have to interpret that. So what sequence is, it is a charge. It is one of the charges in that H number or that reference, and there might be 3 sequences, 3 separate charges under the one H number, and sequence 1 might be an armed robbery. Sequence 2 might be robbery with no weapon, so it's not armed robbery. Sequence 3 might be assault police, and the person might be pleading guilty to sequence 2, the robbery, and because they're pleading guilty to sequence 2, the prosecution might say we're withdrawing sequence 1, the armed robbery, and we're withdrawing sequence 3, the assault police, and then they'll get a sentence date for the one charge that they've pleaded guilty to, and the prosecutor will hand up the fact sheet, which might be called a statement of facts, a statement of agreed facts where the 2 sides agree that that is what happened, or police fact sheet, which is a document the police type once a person has been charged at the police station. It's a summary of the arrest, a summary of the allegations, and police comments about observations of the accused at the time, so a few pages. So those documents are then given to the court, the magistrate, and they will be read when the person is eventually sentenced. So I'll just, do we have any questions on any of that before I move on?
There's no questions at the moment, Helen. There's just a comment that people are really liking the way you're explaining things in plain English. So I guess it's just keep going. Yeah.
Okay, good.
All right, but we can pause if anyone does have any questions. Again, remember, for the people who came in late, you can raise your hand. There's a button to raise your hand, and you can come off mute to ask a question. That's fine. Or you can type your question into the chat. And just do that anytime. And I'm going to put a couple of handouts also in the chat. So that will be the slides that you can refer back to later. And there's also a tip sheet we hand out, which is on tips for interpreting in court. So I'll put those two in the chat while Helen's talking. Thank you.
So we've got bail or release applications. Both words are the same thing. It's the Bail Act. The piece of legislation is the Bail Act 2013, New South Wales. They're referred to as release applications. In other words, release from jail, release on bail. So interchangeable: bail application, release application. What is bail? It's you're not free. You're out of jail, but you've got conditions that you must follow. You maybe have to stay home during the night time. You may have a curfew. You may have to report to police 7 days a week. You may have to live at a specified address. You may have to not be allowed out of home unless you're in the presence of mum or dad. Depends what the conditions. You may be restricted in who you can talk to, like, for example, cannot contact the alleged victim. So bail is not freedom, but it does mean that you're no longer in jail waiting for your case to continue at court, but you do have restrictions in the community. Bail is decided by the court, by police. First of all, police can give a person bail, and but if the police don't give bail and the court decides to give bail, the chances are that the court will give more conditions than the police laid in the first place. So the court, as I said, can impose any number of conditions, or it might also be don't take drugs or don't drink alcohol. Depends on what the factual situation, the allegation is. If alcohol was a factor, allegedly, or drugs might have been an alleged factor, the person might be told you can't do that and you'll be tested randomly. So bail, magistrates have to look at this legislation. So when I'm preparing a release application, I look at the legislation, the Bail Act. And there's a question, is this a show cause offence? And it can be very hard to get people bail, to be honest, because there's a whole list of reasons that make it harder. And I call show cause, my own word for it is like it's a hurdle. You're in a race and you've got to jump over an extra hurdle if this is the situation. It might be that somebody is already on parole, in other words, serving the end of their sentence in the community on parole. They might be on bail for another charge when they're alleged to have committed this new offence. So might already be on bail. The offence may carry life imprisonment. For example, murder carries life imprisonment. Very hard to get bail on a murder charge. An example where you may get bail is if the facts suggest that there's a very strong self-defence element, or an issue with identification, or it might be a very old offence and maybe the person has been living in the community with no charges for 20 years, but now they've been charged with this murder charge. So there might be some reason why it's thought that it's appropriate to give that person bail. But any charge with a maximum penalty of life imprisonment is one of these called show cause offence. It's an extra hurdle. You have to explain to the magistrate why you think this person should be given bail. And there's no set list of reasons that get you over that hurdle. So I just try and throw in anything I can to try and get over that hurdle. Maybe you're arguing that the prosecution case is for some reason weak or not strong. It may be that it's going to take a very long time in court to reach the conclusion of the matter. And that's true of a lot of matters. There might be an 18-month delay. So if the person doesn't get bail today, then they're going to be spending at least 18 months waiting for their case to reach the court. There's a big backlog in criminal law trials. It may be a whole host of other reasons. Maybe the complainant has credibility issues, etc., etc. Health reasons might be a reason. The person might be extremely sick and they might need to get medical treatment in the community. So many reasons why you may say that this satisfies that hurdle. But that's not the end of the story with bail. There's also bail concerns, which are...
So Alex, to connect me with the restructuring guy that he knows.
Oh, sorry, I can hear.
From high school.
Okay.
Sorry, I've just muted them.
Thank you. So there might be a concern, is this person, if they're released on bail, is there a risk that they are going to commit further offences while on bail? And the magistrate will look at the criminal record of that person. Well, yes, every time in the past this person has been given bail, they have committed a new offence. So yes, there's a very high risk that they're going to do that again. So bail refused. Or maybe their criminal record shows that every time they've been given bail, that they have always turned up to court. There's no allegations of failing to appear in court. So the magistrate or the judge may be confident that this person will turn up to court, because bail is really, you want the person to turn up to court to face the charges. That's what bail until the next court date. The court needs to be confident this person's not going to leave Australia, they're not going to leave New South Wales, that they're going to face the charges. If there's a concern that this person is going to cause harm to the alleged victim or any other community member, and again, look at the criminal record or look at the fact situation. Is this a domestic violence offence where the person is going to remain living with or nearby to that alleged victim? Is there somewhere else for this person to go and live? Because if there isn't, and they're still asking to live in the same place as the alleged victim, then there may be, the court might think, a real concern that this person may threaten or intimidate a prosecution witness, the alleged victim. So that might be a reason. If there's no alternative address, it might be a concern that there's a real risk that this person might interfere in the prosecution case, with witnesses, with the alleged victim. So those are concerns that the court has to consider. And if there are no conditions that the court thinks that they can put in place, like no residence condition, no alternative residence, or no restriction about drugs or alcohol, or no restriction about do not contact this person, or no curfew that can make the court convinced that this person is not going to commit another offence, not going to interfere with other people, not going to cause harm to the community, then bail will be refused. But if the court is convinced that if they give some conditions, strict conditions, surrender passport, report to police every day, do not contact the alleged victim, go and live 50 kilometres away, etc., etc., if those conditions can help alleviate the fear that this person might commit another crime, interfere with people, if there are conditions in place that can make the court think, okay, I think this person will behave themselves on bail, then bail can be granted. there's also on that slide section 74. So that's a section of the Bail Act where if a person has already made a bail application, example, in the local court or in the district court, if they've already made a bail application and lost in that court, then they can't have another go at bail unless there is something which essentially materially affects or changes the situation. You can't just keep having another try at bail applications. So an example of that is maybe there's a new statement by the prosecution witness which weakens the prosecution case. Maybe somebody has said, look, I really don't wish to come to court and give evidence against that person. I would like police to withdraw the charges. That might weaken the prosecution case. Or maybe somebody has medical issues which didn't exist before but do now. They've had a heart attack, or maybe they've got into rehabilitation. Maybe they've been accepted into a drug rehabilitation unit, which wasn't available when they first made their bail application. So the court might think, well, that's good, that's positive. Let's let them go and do drug rehabilitation, give them bail to go and do that. And that's something different that wasn't available before. So they might pass the test. But if you're trying to make a second or third bail application with nothing changing from the first time you made it, then you won't get over that hurdle. So that's a hurdle. That's section 74. Also, if a person represented themselves on bail, no lawyer, the first time, then usually they will be given another chance if they now have a lawyer. But it's up to the magistrate. So the magistrate or the judge can say, no, I'm not going to let you continue speaking, bail refused. So that's a release application, bail application, and you can make those in local court, district court, or Supreme Court. If you failed in the local court, which often happens, magistrates may not be willing to give people bail, then you can apply to Supreme Court, but Supreme Court will not hear your bail application unless you have first made an application and been refused in the lower court. So a lot of people do succeed in the Supreme Court after first failing in the local court. So next slide. Okay, so people at court. One person that may be at court is yourself, the interpreter, and you might be asked to come step forward near the microphone, or if you're interpreting for a witness, whether it's the accused or an alleged victim or another witness, then you will be sitting next to that person near the microphone in the witness box, sort of between the jury and the judge, or if there's no jury, just near the judge. Or you might be sitting next to the accused in the dock where the accused is sitting in the courtroom. So interpreter is there. We have lawyers. In the local court, you can't actually tell the difference in clothing between barrister and solicitor, because in the local court, the barrister does not wear their wig and their black robes. But in district court and Supreme Court, you can tell who the barristers are because they have a wig on and the black cape, the black cloak. There you might have some barristers as senior counsel or King's counsel, now that it's the King of England, no longer the Queen. So senior counsel, King's counsel, or junior barrister. Solicitor. So myself, I'm a solicitor, so I don't wear the wig and I don't wear the black cloak, but I'll be in a suit of some description, some colour. And so just to be clear, barristers and solicitors, they're both lawyers, they both have a law degree. but barristers will have sat the bar exams, and as a solicitor I haven't sat the bar exam, but I might still appear on sentence without a barrister. Usually in a trial, if my client's pleading not guilty and going to trial, usually in a trial I will have briefed or engaged a barrister. So there'll be two lawyers for the defence. There'll be myself, a solicitor, and a barrister wearing the wig and the cloak, and the barrister will be cross-examining the witnesses. But if I'm appearing in court without a barrister, then I will be the one cross-examining witnesses or asking my client questions when they give evidence in chief, or I might make the submissions in court when my client pleads guilty. So I do appear in district court sentences, local court sentences, release applications. So I do all that without a barrister, or some people have a barrister for all those things as well. So solicitors can still do the same job as a barrister. They're just not wearing the fancy clothes, but you can also have solicitor and barrister. And in that case, it will be the barrister that does most of the talking in court, but the solicitor will do all the documents leading up to different applications that have to be done in writing. You have the solicitor preparing those documents behind the scenes, and there might be written submissions which either solicitor or barrister will prepare. So that will change the role or the dynamic in the courtroom if there's both solicitor and barrister. District Court has judge. They're called Your Honour. Supreme Court has justice, but called Your Honour. Registrar will be there in each court, local court, district court, Supreme Court, and they might deal with administrative tasks, giving court dates, approving access to subpoenaed documents, and magistrate is also called Your Honour, and they are in the local court. Police prosecutor is a sergeant. Their rank is sergeant, but they're not in police uniform in the local court. They're in the local court. They're not in police uniform, but they are ranked as sergeant, and they will be at the bar table with the defence lawyers in the local court, and they will appear when somebody is being sentenced, and they will appear when somebody is being defending a charge, and they will present the evidence against the person and call witnesses for the prosecution, but they're not in police uniform. Crown prosecutor is a barrister that is employed either by the Office of the Director of Public Prosecutions, which is a government department, just like Legal Aid is a government department, or the Crown prosecutor might be hired for that case by the Office of Director of Public Prosecutions, but normally they might be a private barrister working for themselves. They might do both defence work and prosecution work, but for that particular case, if they're engaged by the Office of the Director of Public Prosecution, they'll be referred to as Madam Crown if it's a woman, or Mr. Crown if it's a man. So that's not their surname, it's just they're referred to as the Crown. So yes, I can just see magistrates will also be in children's court as well. Court officers will be in a blue uniform, and they assist the court and the parties by passing documents, collecting documents from the lawyers and handing them up to the judge's associate or directly to the magistrate. They'll sort of be walking around the courtroom a bit. They'll also assist the jury by taking the jury between courtroom and jury room. And yeah, so they're in a blue uniform. They'll also be involved in getting witnesses up on video screen in AVLs and all of that. And you, as the interpreter, might need to approach the court officer when you're waiting for your booklet to be signed by the court officer to say that you appeared at court that day, and that the court officer signs your book to confirm that you have turned up and interpreted at court that day. So that's the court officer. Sheriff, they deal with a lot of the security aspect at court, and so they might be at the front of the court sheriff's office. They might also be locking up the courtrooms, unlocking gates and things like that. Depends on what the court house looks like. And they might also be involved in meeting the jury panels as well and explaining things to jury panel. And they have other tasks that you don't see outside of court, involved in summons for jury panels and things like that. So jury is something that is used in New South Wales. Some jurisdictions overseas do not have juries, but we do have juries in New South Wales and other jurisdictions in Australia. And jury is 12 random persons randomly selected from the community, and we don't know their names, we don't know what jobs they do, we don't ask them any questions, we don't investigate them. So unlike many of the American jurisdictions or American shows where you see they are cross-examined, they're asked questions about their prejudices and biases, we don't do that. So we can challenge jurors, we can ask for them to be eliminated from the jury, the 12 people selected to hear the case, but we don't know anything about the person. They're randomly selected. So yeah, and so jury is part of a trial in the district court or Supreme Court. They're not required in the local court.
So Helen, maybe just before we move on to the words, there's a question about, this might be more about whether barristers or solicitors cost more, charge more, but I guess there's a bit of a difference between, people don't engage barrister directly instead of a solicitor.
So with legal aid pays, if somebody has a grant of legal aid, legal aid pays the barrister a set fee, and those fees are available on our website. It's public what the barrister is paid. So the client doesn't pay the barrister either. Legal aid pays the barrister a set fee for various sorts of work. Appearing in court for 1 hour will be a set rate. Appearing in court for a day, per day of trial, will be a set rate. It's called fee scales or scale of fees, and that's published on the Legal Aid website. The barristers know how much they will be paid, how much they can pay, and Legal Aid as a government organisation pays that invoice. If it's a private person, if the person does not have legal aid, then it's up to the individual barrister as to how much they charge for the work that they do. And that would be some sort of an agreement either between client and barrister directly, or between solicitor who engages that barrister and the barrister. But the client would know that this barrister has charged this amount of money per day, and there would be a cost agreement. There'd have to be an agreement. So if a person is paying the solicitor and barrister privately, there would be an agreement between the client and the solicitor about solicitor fees or rates and barrister rates. There'd be some sort of a prior cost agreement in place. Normally, I think the barrister would charge more than the solicitor, but some solicitors might also charge a lot. As legal aid solicitor, I don't charge clients any money. I am on a salary, so I don't ever send a client an invoice. And the barrister that I engage is given a set rate. The client does not pay them any money.
Yep. And someone was also interested in this and has put in the links in the chat.
Great.
So thanks for doing that. Yeah.
So private rates totally up to those individual solicitors and barristers. Yeah.
Thanks, Helen.
So yep, so I think we've covered the people at court. Oh, the associate is an assistant to the judge or the justice. They sort of deal with all the paperwork with the judge. They may also, they handle the exhibits in court, documents that are attended. They handle all those documents. They might communicate with the parties by email, and they're kind of the intermediary between the lawyers and the judge. So you don't contact, I'd never email a judge directly. If I've got to email something, I would email the associate, but only with consent of the other side, the prosecution. And in court, so the associate's really assisting the judge. They might also be involved behind the scenes in a lot of research that the judge wants done. Next slide. So common words used in court. Prosecution. So that might be the police prosecutor that we mentioned before, who is a sergeant. It might be a lawyer, a solicitor, or a barrister, the Crown prosecutor for the prosecution. They bring the evidence against the accused, whether the accused pleading guilty or not guilty, they bring the evidence against the accused in that case. The defence is it can be a noun, or it can be a noun in the sense of what is the person's defence, in the sense of, is it self-defence, is it duress, is it I didn't do the crime, or I couldn't have done the crime because I wasn't in Australia at that time, I have an alibi. So is that what we mean by defence? Or is it the defence people, like the defence is the lawyers for the the lawyers for the accused are the defence representatives, the defence counsel, the defence solicitor. So defence can have a couple of meanings. Defendant is the person accused of the crime. They're defending the charge. They're saying they didn't do the crime. And I'm speaking about criminal law words. The defendant would also is also in civil cases as well. They're defending the civil case, the civil allegation, civil lawsuit. But I'm focusing on crime. The accused there's an allegation against that person. They've been charged with a crime. They're accused of it. The co-accused is another person who is also accused of the crime. For example, you might have 5 people accused of growing cannabis in a house, and they're all accused, they've all been charged, they're co-accused of the same crime. And the prosecution might be running their trials all together in court. So you might have 5 people in court, all accused of the same crime. They will all likely have separate lawyers, and if they speak different languages, they might have different interpreters, different languages interpreted, yet they might all have their own interpreter at court. Offender is the word used when somebody has either pled guilty or they've been found guilty. They've gone to trial, they've lost, they've been found guilty, and now they're going to be sentenced and receive a punishment for the crime. So now they become the offender. Co-offender is somebody who's also either pled guilty or been found guilty. They're the co-offender. If something is fixed for mention, a date is given to come back to court in the future for mention. And a mention is a short court appearance where the court, whether it's the magistrate or the judge, is maybe checking, have the police served all the documents yet? Are the parties ready to proceed to trial next month? Have the parties filed their submissions that they were required to file in time? It's a mention, it's an administrative thing. The case is not going to be finalised on that day. It's really for the court to check if everything is progressing like it should. So it's in the meantime, the case is still ongoing. If it's listed for mention, you can expect it to be a fairly short court appearance. And when I say short, you may still be stuck at court as interpreter for 3 hours waiting for the lawyer to be able to mention their case, because there might be 100 other cases in court that day, especially if it's local court. However, when they actually mention the matter, when they actually appear, it might actually be only 5 minutes at court. Very frustrating for everybody, but if it's for mention, it's not going to take very long once it actually gets spoken about or mentioned. Hearing or a trial. So I touched on this before. A hearing is a word, so a local court defended hearing. Somebody has pled not guilty. They're asking the prosecution to bring the evidence against them, to prove the case against them beyond a reasonable doubt. That's a hearing. That's local court. But you may also have a sentence hearing in the district court or the local courts have pled guilty. Submissions are going to be made by both sides. Evidence will be tendered in court documents. And so hearings, so submissions are going to be made, evidence is going to be handed up. Sentence hearing or a bail hearing or release application. There's going to be some arguments, there's going to be some submissions made, some talking done, some documents given to the court on a bail hearing or a hearing of the release application. So it can be various jurisdictions, local court, Supreme Court, District Court, hearing, Children's Court, hearing. Trial is District Court or Supreme Court. Somebody has pled not guilty. They've left the local court, they've gone up to District Court or Supreme Court, depending on what that charge is, and they're now having a trial. The prosecution is presenting the evidence, calling witnesses, and playing videos, whatever that evidence is. And the jury, those 12 people randomly selected, will be listening to the evidence and perhaps determining guilty or not guilty. Or if the person has elected to have no jury but just the judge of the district court or the Supreme Court, then it'd be the judge that decides guilty or not guilty. But in the Constitution, the Australian Constitution, a person has a right to trial by jury. So they have a choice. They can choose not to have that jury, but the standard or the default position, if I can call it that, is it's going to be trial by jury by 12 persons. And in that sense, the judge's role is to make sure that everything is fair and that only relevant and admissible evidence is allowed to be heard or seen by the jury. And there might have to be some legal argument by the prosecution and the defence. So there's those words, prosecution and defence, about what is admissible or what is inadmissible, what's permitted and what's not permitted for the jury to be hearing and seeing, what's relevant or irrelevant, what's so prejudicial it shouldn't be heard, or what's prejudicial but still very important for the prosecution case that it shouldn't be ruled out of the case, that the jury should be hearing this. So that's what the judge has to decide, those legal arguments about evidence and ensuring that everything is done properly and fairly so that the accused gets a fair trial and in a sense the community, which is represented by the prosecution, also receives that the trial is fair for the community. Special fixture, sometimes a case will be given a fixed date because it's a particular length, a particularly long case for a local court hearing. So it's like a guaranteed date. You're going to be guaranteed that you have a magistrate available in that courtroom for 3 days or something. It might be a special fixture. It's absolutely going to be guaranteed time and space to be heard on that day. Because sometimes you turn up to court, district court or local court, and there's no judge or magistrate available, and you wait all day and it doesn't get reached, and so then you have to come back another time. It's adjourned. So special fixture sets it down, guarantees this will be given time and an audience, be given a judge or a magistrate. It will be running on that day and time, guaranteed before a person. Evidence in chief is the witness is called, for example, a prosecution witness is called to give evidence by the Crown or by the police prosecutor or by the prosecution legal representative. And when that person talks, when they talk in court and they're asked questions by the prosecutor, that is their evidence in chief. When they are then asked questions by the defence legal representative, that is called cross-examination. And likewise, if the accused is called to give evidence, if the defendant is called to give evidence, or the offender is called to give evidence in their sentence proceedings, it is their legal representative that asks them questions first. That is the accused or the offender's evidence in chief. The questions are asked by their own legal representative, and then they are able to be cross-examined by the prosecution. That's cross-examination. The other side asking questions is cross-examination. So you will see that, and you might have to interpret in both evidence in chief and cross-examination.
So Helen, after this slide, so in a minute, we're going to have a break. So we said we're going to break it up into after an hour, have a break. So we're going to have like just a 5-minute break, I think, to go to the bathroom, grab a coffee. There's one question though related to hearings. Someone's asked, what is a directions hearing?
So often in any jurisdiction, but often you might get this in district court or Supreme Court, there will be what's called a mention. It'll be mention, and the judge might give a list of orders. Example, I want the prosecution to file submissions about this topic by a certain date, and then the defence are directed to file their submissions in reply by a certain date. So a timetable might be set because there might be a lot of work that needs to be done and decisions need to be made about admissibility or inadmissibility about certain evidence, for example, before the trial actually starts. So the judge or magistrate will give directions about, give a set of orders about what must be done by the two sides before the trial or before the sentence starts. Then people might be directed to file documents by a certain date, and you'll be given orders, and you may have to explain to the court why you have failed to do that. Or you might be directed for sentence proceedings. The prosecution will be directed to file their submissions and material 2 weeks before the sentence, and the defence is directed to file their material 1 week before the sentence. They're standard orders, they're directions. Sometimes the case may be particularly complicated. There might be lots of accused. There might be a long history of problems with the case for various reasons, a lot of evidence, and the court might say, well, what are the lawyers doing? Stop mucking around. I want this sorted out, narrow it down. You know, think about exactly how many witnesses are going to be called. You know, by this date, I want these tasks performed. I want these tasks done, and they'll be given directions, given orders.
Great, thank you. So the comment is like scheduling procedure prior to the trial. Is that a
Yep,
good
absolutely.
example?
Timetable, or it may even be prior to the sentence. A timetable is set, tasks are allocated, things must be done.
Great. All right. Thanks, everyone. Well, we're going to have a 5-minute break. So it's now 10:45. So we'll come back at 10:50 and start again there. So we'll turn off our cameras now and just have a 5-minute break. Thanks, everyone. All right. 5 minutes is very short, isn't it? Maybe we can have a 10-minute break next time, but we'll see how we go. All right. Look, I can't tell if everyone's back, but I guess we can just start. And like we mentioned before, it is being recorded, so you can always go back if anyone's missed anything. All right. Is this where we're up to? Yes. So
Yes.
we're still in court, learning about the different words that people might hear in court. Thanks, Helen.
So committal hearing is something you may hear in the local court. It's about a process for some matters, some of the more serious matters that will end up in the district or Supreme Court, a committal hearing. The magistrate, when a person pleads guilty or not guilty, the magistrate commits a person to the higher court, commits a person for trial, or commits a person for sentence. If they've pled guilty, commits a person for sentence in the higher court, being district court or Supreme Court. A committal hearing is an application made by usually the accused person's legal representative, but can also be made by the prosecution or might be agreed to by the prosecution, to have some, not all, witnesses brought to the local court for cross-examination, meaning answering some questions about their evidence that they gave in a statement or an expert report or something, while the matter is in the local court. It's an application that has to be made very specifically, setting out which witness you're asking for, because you're not going to be able to do this with every witness that has given a statement in the police brief of evidence, which witness you want to cross-examine in the local court, committal stage, and what specific areas are you asking permission from the magistrate to cross-examine them on. So that's an application that needs to be made, because it is not automatic in every case. In fact, it's quite rare. And there are strategic reasons why you may choose or not choose to do this. It might be a case where there's a particular expert evidence, might be ballistics, might be a robbery or something where a gun has been fired or not fired, and there might be some evidence that you might want to cross-examine the expert about. You might want to test the evidence. You might, to see how strong it is, you might want to be able to test it to try and weaken it. There might be trying to achieve to weaken the evidence. There might be an identification issue. There might be a group of people involved in a fight, and maybe your client doesn't match the description of that the witnesses give of people involved in the fight. Maybe there's confusion about who did what, or descriptions of people. So maybe you want to test the strength or put in some doubt or weaken that. So various strategic reasons which you may choose to do this. So you might be trying to weaken some evidence and then use that weakened evidence to tell the prosecution or suggest to the prosecution that, look, your case just got weaker and you might wish to consider withdrawing the charges. Or it might be that you want to test what the answers would be so that you know now, and you'd think twice about ever asking that question in front of the jury when you go to trial in the district court or the Supreme Court. So you might get the answer, and it's not something you want to run for the first time in front of a jury. So you leave it alone if it doesn't go your way right now. There might also be a reason why you choose not to do this, and it might be because you might give the prosecution or police a chance to fix the problems in their case. So you put all your cards on the table as a defence lawyer, it might actually give them a much more time to fix their problems. And that might be something you choose is not worth doing. So you might think rather than giving that person a taste of what cross-examination might be like, maybe you think it's best don't give them a preview, let them feel it for the first time in front of the jury. So there's various reasons strategically why you may do this or may not do this. But the magistrate does not have any power to discharge or get rid of the charges after this hearing. So either way, whether you do this or not, that case is going up to the higher court. It is not going to be kicked out of court by the magistrate. The magistrate does not have the power to dismiss charges. They used to in New South Wales, but they do not anymore. The magistrate's role is much more administrative in these sorts of more serious matters. So plea is entered. Plea of guilty, you're committed for sentence in the higher court. Plea of not guilty, you're committed for trial in the higher court. I'm just looking at this question. If a case goes to the higher court, would the jury follow? Yes, juries, if it's a trial, then a jury will be selected in the district court or Supreme Court. If it's committed for sentence in the higher court, then there is no jury. Call over can be it's usually district court or Supreme Court. A call over is usually, for example, it might be a few days before the trial is about to begin, and the judge is checking, are you ready? Are you ready to start on Monday? So in Sydney District Court, for example, trials have a call over on the Thursday before trial is scheduled to start on the Monday. So on Thursday, the week before, we go to court and the judge says, are you ready to proceed? You sure? You're ready to select a jury on the Monday. So it's kind of they're checking how many jury panels do we need? Are we likely to have a judge available or not? Or is this a case where there has to be legal argument first? They're really checking length of trial, just confirm the length, all of that sort of thing. So they're trying to manage the diary as well. How many judges do we actually have? Is this case likely to start? Is it 5 days in length? Is it still 3 months in length, or have negotiations happened and is it now shorter? What are the lawyers telling the court? So it's really checking who is ready to go. Maybe somebody's decided to plead guilty and it's no longer going to be a trial, so the court wants to know, can we pull that case out of the list?
Sorry, Helen, that question in the chat, I think, do we just need to clarify that the jury is only selected once the matter is already in the higher court? It's not at that committal stage?
Correct.
Is that what the question is? Yeah. So the jury doesn't go to a different court. The jury's only selected once it's in the final court.
There's no
destination
jury.
Court.
Yeah, there's no jury in the local court. There's no jury at all in the local court.
Okay, hopefully that answers the question. Thank you.
So adjournment is, there's going to be a next court date. So an adjournment is the matter might be mentioned, there might be a call over, and it's put over, it's stood over, it's adjourned to another date. So it might be adjourned for trial, it might be adjourned for further mention, it might be adjourned for sentence. That's an adjournment. Or it might be adjourned for judgment. The judge might want time to think about their decision in a matter. They might want time to think about what penalty they're going to impose, and so they delay it and they adjourn for the next a future court date. That's an adjournment. Lawyers can apply for an adjournment as well. So they might say, well, we're not ready to proceed today, but we'll be ready next week. So they might apply for an adjournment, a delay. Stay or stay of proceedings. There might be an application to temporarily or permanently stop or stay proceedings. And this is quite rare. There might be a couple of reasons. It's hard to achieve as well. So there might be some reasons that this may happen. It might be because of the chronic or urgent ill health of a person. I've had clients who've had cancer diagnosis and receiving chemotherapy or something, things like that. Other reasons might be a person may have run out of money and they're not eligible for legal aid for whatever reason. They might have too many assets, or they may still have a job, but they can't afford the private lawyer anymore. They've run out of money, so they might be asking for a temporary stay so that they have time to save up more money for their legal fees. There might be an application for stay of proceedings because police have lost important evidence, and without those documents or that evidence, the accused might say, I can't get a fair trial because police have lost or destroyed crucial evidence to the defence case. So that might be an application to stay proceedings for that reason. So it's really hard to achieve though, but it has to be legal argument and an application made for that. Proceeds of crime is money, or might be money which results in purchase of a property or a car or something like that. Proceeds of crime as a result of crime. So a crime might have been committed, might be an armed robbery, might be selling of drugs, importing of drugs, and money has been made as a result of that crime. And then that money made from the crime has been spent on a house, a car, jewellery, whatever, that proceeds of crime. And the prosecution may make an application for that property or that cash to be forfeited or given up, surrendered to the court or to the prosecution, to the police, because it's illegally obtained money or property. So there might be an application to confiscate the property and to forfeit that property, or also forfeit the drugs and destroy, application for the court to destroy, order the destruction of those drugs, things like that. So very often in drug cases, there will be proceeds of crime application or money laundering, things like that. There might be property seized, houses, cars, jewellery, or money seized, and then an application made by the prosecution or by the crime commission for confiscation and forfeiture of that property. And the orders are pretty easy to get, pretty easy to achieve once there has been a plea of guilty or convictions after a trial. So then the orders are made to forfeit that property or that cash. Sometimes the cash no longer exists, and that's a problem. The cash may have been spent by the person, but there's still an order made to forfeit the money, even if it physically may not exist as well. That's a whole other problem, but the order is still made. Jurisdiction can have a couple of meanings. In English, it can have a couple of meanings. Jurisdiction can be the location, the physical place, like New South Wales, the state of New South Wales, the state of Queensland, can be Australia, could be an overseas jurisdiction, could be India, could be China, could be United States. So jurisdiction, where is this crime committed? Who has jurisdiction over this matter? If the crime is committed in New South Wales has jurisdiction. If it was committed in Queensland, Queensland has jurisdiction, and the police in Queensland should be prosecuting the case. If it's an import drugs, then are they imported into New South Wales, then usually federal Commonwealth will prosecute it in the state of New South Wales, but it'll be Commonwealth prosecutors and Australian Federal Police investigating and prosecuting the case within the state, within the jurisdiction of New South Wales. It may also be, does this court, whether it's local court or district court or Supreme Court, have jurisdiction to hear this case? There might be a question mark whether this legal proceeding, this case, has been brought to the correct court, and the judge may or may not have jurisdiction to hear that case. Sometimes cases are transferred back to local court, from district court transferred back, or they might be transferred up from local court to district court, and there might be some reason to think whether it should have been transferred or not, or whether it could be transferred back or not. So there might be a question over who should be hearing that matter, and is this the right place to hear it? Because if it's not, then any orders made are in effect invalid. So the jurisdiction needs to be correct. If there's a jurisdictional error, then it can lead to an appeal, or for those orders being made invalid. So judicial error is a mistake by the judge, or the judicial error, mistake by magistrate or judge. It's a legal mistake. It's a mistake that they've made in the law or in the application of the law. They've made an error. There might be example, they've applied the wrong maximum penalty of a charge, or they've allowed evidence in which should not have been allowed in because they have misapplied or misunderstood the legal test or the law. So that might be a judicial error which results in an appeal against that judicial error. And it might be an appeal to the higher court. So an appeal can be against severity or against conviction, severity of sentence, severity of punishment, or length of sentence, or it might be severity in the type of sentence. So somebody might have been given a jail sentence or an intensive correction order, which is a jail sentence served in the community, and they might think that's too severe. And they might be asking the higher court to lessen that sentence or reduce the length of it and impose a different sort of sentence, something less severe. Or it might be an appeal against conviction. So they've pled not guilty, but they've been found guilty by the magistrate in the local court, or they've been found guilty by the jury or judge in the district court or Supreme Court. Now, if they're appealing against conviction by a magistrate in the local court, then the appeal is to the district court. They can go from local court to district court for appeal. And then the judge will look at whether the conviction was appropriate on the evidence or not, or did the magistrate make an error? Was there an error in convicting that person? Or if the trial was in the district court or the Supreme Court and the person wishes to appeal against the verdict of the jury or the judge alone, then they have to go to the Court of Criminal Appeal. And at the very beginning, we sort of had that hierarchy of courts, and the Court of Criminal Appeal is physically within the Supreme Court building in Sydney. There's the Supreme Court building at Queen's Square near St James train station. There's a Court of Criminal Appeal, and the Court of Criminal Appeal is 3 judges, and they read all the transcripts, look at all the evidence that was heard, look at the legal arguments, look at the judge's directions to the jury, the judge's instructions to the jury, and did the judge make a mistake? Was the jury's verdict reasonable under considering all the evidence. So that's appeal against conviction. It's a very long process and slow process to appeal to the Court of Criminal Appeal. And Legal Aid does represent many people in those appeals, but they have to apply for legal aid, and there's a test whether there is merit, whether there's prospects of success. So a barrister will look at whether this is a reasonable appeal or not, whether there's reasonable prospects of succeeding. And if yes, Legal Aid will pay the money for the lawyers to appear at the appeal. And that goes back to that fee scale. There's set fees for that. If Legal Aid, if the barrister decides no, there's no merit in that appeal, then Legal Aid will not pay or fund that appeal in that court. But some people represent themselves as well in the Court of Criminal Appeal, and they write their own submissions and verbally represent themselves. So summary offence, there's a Summary Offences Act, and they're much less serious crimes, but you can still get jail for those offences, but they're always finalised in the local court. An example of that might be receiving stolen property, goods in custody, having something in your property, in your pocket or in your home which is reasonably suspected of being stolen. An example that has 6-month maximum penalty. So summary offences are considered less serious, and they're always dealt with in the local court, and the Summary Offences Act. Indictable offences, by definition, under the legislation, have a 2-year maximum penalty. They're a crime that has a 2-year maximum penalty. Lots of things have 2 years or more, so lots of crimes are indictable, and they might be dealt with on indictment. And an indictment is a charge on a piece of paper. So an indictment is a document which has the charge or charges written on a piece of paper, and it's presented to the court in the district court or the Supreme Court, and that's what's the indictment. It is literally the charge or charges written on a piece of paper that Helen did on the 20th of November 2003, rob the 7-Eleven store of a packet of cigarettes. So that's the charge, and that's on the indictment, and that's read out to Helen when she is arraigned in the district court, and she pleads not guilty and gets a trial date in front of a judge and a jury. She goes to trial, and they find her not guilty, of course. So then she's free, she's acquitted, and she's allowed to go home. So you're indicted, that means that the charge is presented and you are indicted on that charge. Arraignment is the act of pleading guilty or not guilty in the higher court. The charge is read out to a person and they plead not guilty and they go to trial. If they plead guilty, then they obtain a sentence date and are sentenced. If somebody's found not guilty, then it also means they're acquitted. They're acquitted by the jury. Or to acquit somebody is to find that person not guilty. The verdict is not guilty. That means that they're acquitted of the charge or the allegation or the charge on indictment. If they're found guilty, then they're convicted. They're also convicted if they're found guilty. Penalty is the punishment, but a penalty may be anything from a fine, a good behaviour bond of sorts, and we'll get to penalties later. It can be jail, can be money, can be a fine, that sort of thing, and various sorts of what we no longer call good behaviour bond, but that's the equivalent of conditions in the community to observe and follow certain rules, be supervised, maybe go to the doctor and get treatment, maybe don't take drugs, don't consume alcohol. So penalties have a wide range. There's a wide range of penalties, and they are imposed by a magistrate or a judge when somebody pleads guilty or has been found guilty. If somebody is on remand, that means that they are not released on bail, that they are bail refused, and they are remanded or held in jail or in custody at jail, at a prison, waiting for their next court date. So they're on remand. They haven't been sentenced. They haven't been punished. They haven't been found guilty. They haven't been found not guilty. They're waiting for their case to come to court and be finalised. So that's remand. They're remanded in custody, and they're under the supervision in jail of corrective services. You can be in custody of police, or you can be in custody of corrective services. So when somebody is arrested by police, they're not free to go. They're not free to walk away. Police are holding them either in the police car on the way to the police station, or at the police station, or in the police cell. They are held in custody by police while they're waiting to be interviewed, while they're having their forensic procedures. They're held in police custody for interviewing, for processing. Once they go from, if police refuse bail, then they go into corrective services custody. Corrective services take over the supervision and care of the person and hold them either at the corrective services cells at jail, and as an interpreter, corrective services cells at court, or corrective services cell at a jail. Now, as an interpreter, you may have to attend the cells at court with the lawyer, and you might have to interpret between the lawyer and the accused person who may have just recently been charged and brought to court by police, and you might need to interpret at the courthouse in the corrective services cell. And then you might also be asked to interpret in the courtroom when that person's brought from the cells to the courtroom. So that's custody. So a person's not free if they're in custody. Custody also has another meaning, in possession of something. So I might have custody of a knife, means I have possession of it, whether it's physically in my pocket, in my bag, or in my car that I'm driving. I might have custody of something, some property. Can see some questions. I'm not sure. I'm not sure exactly. Yeah.
Sorry, just on the American terms, we do have a slide later on about what American terms are used that we don't use here. I don't think we've got delinquency on there though, so I don't know if you want to address that now or wait. But are you looking at the one?
Yeah, I'm looking at that.
Above?
So,
yeah.
Look, I think misdemeanor is similar to what we call summary offence. I'm not 100% sure. Like, I'd really have to go and compare the legislations. I mean, I guess each American state has different lists of misdemeanors. I think that's right. I think it's misdemeanor is like summary offence, but I'm not 100% certain on that. So I think so, but I'm not 100% sure. And delinquency, I think it's a person can be delinquent. I think it's just like misbehaving, bad behaviour. But I'm not sure, I guess delinquent can also be a whole range of illegal or bad behaviour as well. And a delinquent can often, people are called juvenile delinquent children, that sort of thing. So I don't want to say the wrong thing, but I think that's correct. Misdemeanor and summary offence.
Delinquent's not a legal term that in Australia anyway.
So verdict is guilty or not guilty, or not criminally responsible because of a mental health or cognitive impairment. So that's the verdict. It's the result in the case after the evidence has been presented. It's the decision. It's the judgment of guilty or not criminally responsible because of a mental health impairment or cognitive impairment. Sentence is the punishment. So there may be a fine, and we do discuss different types of sentences later, but a sentence is the punishment after a finding of guilty or a plea of guilty. Person receives a sentence. Non-parole period and parole period. Every sentence has, a prison sentence has two parts. It has a non-parole period, which is the minimum time which a person spends in jail, in custody, and it has a parole period, which is the period under supervision by corrective services, community corrections, and they might have to go to meetings every week, do random drug testing, that sort of thing, go to the anger management courses, that sort of thing. So it has a minimum non-parole period and a parole period. That's how a jail sentence is structured, and we'll come back to that. So just hold on, I will come back to that. Head sentence is also a slang term, a term used for total sentence. It's the combination of the minimum non-parole period and parole period. The head sentence is that maximum or the total sentence. They're all words that mean the same thing, all jargon that means the same thing. In a trial, if you're interpreting in a trial in the district or Supreme Court, you might hear of a situation where there's a black direction or majority verdict. A black direction, it's a case. It refers to a previous judgment where a situation where jury has said in that case that they could not decide on the verdict. They were split. They were not unanimous. They were not 12 people all agreeing on guilty or not guilty. And they've communicated to the judge in a note saying, we can't decide. We're not unanimous. We are split. Because in New South Wales, you have to have unanimous 12 people agreeing on the verdict. Not necessarily reasons for the verdict, but 12 people have to agree guilty or not guilty before the verdict can be delivered. It can't be 6 and 6 or 10 and 2 or 7 and 5. It has to be 12-0, 12 agreeing before the verdict can be delivered. And if they say, look, we can't decide, we're split, we're disagreeing with each other, then the judge will give what's called a black direction based on this case. And it's a specific wording which the judge will give, saying more or less, go back to the jury room, listen to each other, have more debate, have more discussion, look at the evidence. I want you to try to come to a unanimous verdict. I want all 12 of you to agree. We're not at the stage that I'm allowed to accept the majority verdict yet. I don't think you've been talking long enough. Try harder. See if you can come to the unanimous 12 of you agreeing. So then the jury is sent out again to continue deliberating, to continue discussions. We, the lawyers, do not hear what their discussions are. They're in a private, closed room. We're not allowed to know what those discussions are. And then the jury may still say after that, we still can't decide. If that happens, then the judge, after a while, if it's at least 8 hours that they have been talking for, and that does not include lunch break and it does not include overnight, because juries here are sent home. They're not staying in a hotel room for the time of the trial. They are allowed to go home. If they still can't decide after 8 hours at court in the jury room, making a decision, 12 people together, then the judge might say, okay, it's time now for me to accept a majority verdict. And by majority verdict, it's not 7-5 or 10-2 or 8-4. It has to be 11-1. It might be 11 people saying guilty and one person says not guilty. That would equal a majority guilty verdict. If it's 11 people saying not guilty and one person saying guilty, then that is a majority not guilty verdict, and equals not guilty person is free of that charge. So majority, yeah, it's not 7-5 or 8-4 or 10-2. It has to be 11-1. And there has to be at least 11 hours of jury deliberations, jury discussions, before the judge will even allow jury to say a majority verdict has been reached. If, as a result of can't decide and then we still can't decide, still split, can't even come to a majority verdict, then the jury tells the court, look, we're not going to be able to reach even a majority verdict, and the judge is convinced that they've been trying long enough, and that they may even ask the foreperson, look, do you have any chance of, if I give you more time, if I send you out for more time, do you think you're close enough to reach a majority verdict at least? And if the foreperson says no, they're not asked to say how they're split. In fact, they're told not to indicate how many, what is the division. Then the judge will talk to the lawyers, but pretty much discharge the jury. It's hung jury. They're hopelessly deadlocked. They're hopelessly divided. It's not going to result in a majority verdict, let alone a unanimous verdict. So then hung jury will be dismissed, sent home. And then the accused will be either remanded in custody, waiting to hear if the prosecution are going to retry the matter, or if they're on bail, bail will usually be continued, and again adjourn a new date for the prosecution to decide, are we going to prosecute? Are we going to go through this process again with a different jury, maybe a different judge, maybe the same judge, very often different judge. So that's the process. So if you're in a trial and you hear those sorts of directions and those words, then that's what that means.
And Helen, sorry to interrupt, there is a question about does a member of the jury have a right to refuse to give a verdict at the completion? I guess if they just can't decide.
We don't hear the discussions, but they're meant to give a verdict. I mean, if they're refusing to give a verdict, guilty or not guilty, then they're really not doing their job, because they've taken an oath or made an affirmation to decide their verdict based on the evidence, so that they actually have made a promise to the court to listen to the evidence, watch the evidence, and make a decision based on that evidence. So they're meant to come to a decision. It's okay if their decision is different to everybody else, but they're still meant to come to a decision. So if they say that they're refusing, if they tell the rest of the jurors they're refusing, then I would expect that a juror, can be any one of the 12, would write a note to the judge. The court officer is given a note, is not supposed to read it. The court officer gives the note to the judge. The judge then gives the note to the lawyers, both sides, or reads out the note in the absence of the jury. Jury's not in court at this time. The accused is in court. Lawyers are in court. Reads out the note or photocopies it and gives a copy to the lawyers. Says, look, there's a note here saying there's a juror refusing to give a verdict. Or maybe, you know, who knows, that person might say, I refuse to give a verdict. Then there would have to be the foreperson would be asked to come into court to answer some questions, like what's going on? Is there somebody refusing to answer this question? What's going on? It may result, in fact, in the whole case being aborted. It may result in the whole jury being dismissed, discharged, and having to start again because that person is actually breaking the rules. And haven't had that exact situation, but I have had situations where there have been what's called juror misconduct, resulting in a case, either that one juror being dismissed, but if there's a risk that they have then said various things to other jurors or misbehaved in a way which goes against their promise to the court, then it may have infected the atmosphere in the jury room. It may have affected other people's ability to do their role, and it may result in the whole jury being dismissed at whatever point in the case. And another example of misconduct is jurors doing their own investigations. They're told don't go to the crime scene by yourself. Don't look up the internet and do your own legal research. Don't do this. Don't do that. Don't discuss it with your friends on the weekend. You can only discuss it with your 12 jurors in the jury room when you're all together, not with anybody else. So if there's a report or there's a suspicion that they've done the wrong thing, it can cause the whole trial to collapse and have to restart. So it's stressful on the prosecution witnesses who are then going to have to come again and give all their evidence again. It's stressful on the accused person who may be in jail and may have been waiting 18 months for their trial. It's stressful on all the lawyers, and it costs the community an absolute fortune, paying for jurors, paying for the judge, court time. You know, it's a very serious thing if jurors don't follow the rules.
Thank you.
So more words used in criminal law. So to charge somebody, so to charge is a verb, and a charge can also be a noun. Police lay charges or lay a charge against somebody. So we use it as a verb and a noun in English. So I'm not sure in your languages whether it's the same word is used as a verb and a noun, but in English it can be both a verb and a noun. And so you're charged by police, and police lay charges. A Form 1 offence is something you'll hear quite frequently if you are in a conference where this is occurring, or in a district court sentence, but it can also be in a local court sentence or a Supreme Court sentence, but I would say very frequent in the district court more so. So a Form 1 is a document, a certain format prescribed by a regulation or a piece of legislation. And what it practically means is the person has pled guilty to a main charge, and I'll just give an example just to make it easier to picture. For example, somebody has pled guilty to breaking and entering a home and stealing property from that home. So they pled guilty to that, and they're being sentenced for that. They've admitted their guilt to a charge of larceny of some property which they took from that home. So they've stolen a camera, they've stolen a wallet, okay, and then they've admitted their guilt that they've used the credit cards in the wallet. So they've gone to the shop and they've done tap and go, you know, they've gone on a shopping spree with stolen credit cards. So they've admitted their guilt to those other offences, and they've signed the document, and they've asking the court to take those other offences which they've pled guilty to, admitted their guilt to. They're asking the court take those offences into account on a Form 1 when the court is sentencing them for the more serious charge. And by more serious, I mean it has a higher maximum penalty than the other charges, which are on the Form 1. So court knows they've done this, the court knows they're admitting it, and it will all be dealt with at one time. An advantage to the accused, or the offender, I should say, an advantage to the offender of putting those charges or charge on a Form 1 is that you're not given a separate penalty, which could mean a jail sentence. You're not given an additional or separate jail penalty for that particular offence. So that might be a good thing. It might mean a less overall penalty than if you had those 4 or 5 offences in addition to the more serious break, enter and steal charge. It might also be the case that the prosecution might agree to this when there might be a slight weakness in their case. There might be something about it which is not the strongest case, but both sides aren't really wanting to take that to trial. The prosecution might think, well, if this did go to trial, we could lose. But by the same token, the offender might be thinking, well, if I go to trial, I could lose. So I'd rather, for whatever reason, admit my guilt, have the court consider it when I'm being sentenced for something else. Both sides might not want to really risk going to trial on that. It deals with the case, it's finished in a timely fashion, wrapped up together with the sentence with the more serious charge. That's a Form 1 offence, very common, I would say, in district court. The judge still sees the facts of the offence. The judge knows what it's about. A backup charge is a less serious offence, which is like an alternative or a backup to the more serious offence. So, for example, somebody that is charged with supplying prohibited drugs, and they're also charged with possessing the same prohibited drug that they're accused of supplying. So they might be arrested, and in their pocket is a bag of white powder which tests positive to cocaine. They might be accused of supplying or having that cocaine in their possession for the purpose of supplying it, because the police might allege that it's, too much drugs for a person's personal use. So police assume or presume that it must be in their possession for the purpose of supplying it or selling it. Now, the person is charged with possession of it. They haven't supplied it yet, and they might offer to plead guilty to possession of that drugs, but they might say, I'm not guilty of supplying it, or I'm not guilty of going to supply it. And they might argue, and it's a defence to say that it's personal use. It's in my possession. Yes, I'm guilty of possessing it, but I'm not supplying it, or I'm not going to supply it because actually I'm a drug user and that's for my personal use. And they might give evidence in an interview with police about that, or they might give evidence in court about their drug habit and their personal use of that. So they're saying, I'm guilty of possessing it. Yes, I don't deny it, but it's not for the purpose of supply. Another example might be wound with intent to cause grievous bodily harm, or reckless wounding is the backup charge. The maximum penalties are different. The intention behind it is different. Intending to cause grievous bodily harm is much more serious at law and in penalty, carries a maximum penalty of 25 years, much more serious than reckless wounding. Reckless is less serious than intending to cause that injury. So prosecution may accept a plea of guilty to reckless wounding and withdraw the more serious charge of wound with intent to cause grievous bodily harm. They might accept actually this was reckless, more reckless. Maybe we can't prove the intention so much, but we'll accept a plea of guilty to reckless and sentence the person for reckless wounding. And then you might hear those words, sequence 1 withdrawn, plea of guilty to sequence 2. The backup charge disappears. The backup charge becomes the charge that you're sentenced with, and the more serious charge might be withdrawn. So that's an example of a backup charge. It's the less serious of the 2 or 3 charges. Sentence assessment report is a document, a report, which is ordered by the court, but it might be requested by the accused's or the offender's lawyer. Person has pled guilty, or they've just been found guilty, and they're going to be sentenced in the future. A sentence assessment report is written by community corrections officer, which the old word is parole officer. They work for corrective services. They visit persons or by video link in custody in jail prior to the sentence date. They also they manage cases of people who are serving sentences in the community. They have offices, many suburbs have a community corrections office, and they supervise people in the community. They might conduct random drug tests of persons. They might also send people off for anger management and drug courses. They check how people are going. They might assess the home, the suitability of the home that the person is going to be living at while they're serving their parole when they get out of jail. So they write a report to court. The court has ordered the report, and the report goes straight to the court, local court, district court, Supreme Court. The report may also offer some information about suitability for supervision, suitability for community service, suitability for home detention. So if they say that the person is suitable and eligible for community service, then the court might say, well, I'm going to order that as part of the punishment. I'm going to make that a condition of one of these community correction or intensive correction order. A condition may be go and do 100 hours of community service, but it can only be an order if the person is suitable and eligible for community service, and a person's health may rule them unsuitable, or a person might be in a country, remote, rural area where there is no community service program available. So a person might be ineligible because of geography or health, for example. So sentence assessment report is a report which goes straight to the court, and I always warn a client that whatever you say to that person is not confidential. It goes straight to the court, and if they write things like, this person has blamed all their friends for their crime, this person is not sorry at all, this person has no insight, this person has blamed the victim, it's going to be bad news. So they write an opinion about the person's attitude to the crime. And I always warn my client that they're going to be asked about, why did you do the offence? How do you feel now about thinking about having committed the offence? And if that is given a negative opinion, if the report comes back with negative attitude, negative comments by the offender, then it makes it hard, because the magistrate or the judge reads that and thinks this person, maybe they don't care, maybe they have bad prospects of rehabilitation. So that report can be quite problematic if it's bad. And there's not always much personal information. The other thing that they can do is risk assessments, risk of reoffending, especially with sexual offences. There might be also a psychologist's notes about risk of reoffending, and that will come into the report as well, risk of reoffending. So that becomes relevant on sentence about prospects of rehabilitation, danger to the community, and that those things can impact on the length of the sentence as well. Agreed facts are the facts which are agreed between prosecution and defence and usually are signed by the person who has pled guilty. They've admitted their guilt, they're pleading guilty, and they've agreed that, yes, that happened. All of these facts occurred. Yes, I went into the store, I pointed the gun at the shopkeeper, I demanded $200, I received the money, and I did all these things. So that's agreed facts. Sometimes the agreed facts they're often negotiated. So I, as a lawyer, will read what is drafted and I might ask that the prosecution eliminate certain sentences. There may be no proof of certain things, or it might be irrelevant or too prejudicial, or maybe, you know, when somebody has pled guilty to a backup charge, then anything that the police wrote originally referring to the more serious charge has to be eliminated because the agreed facts have to suit the actual charge that you're pleading guilty to. The agreed facts cannot be more serious than the charge that you actually plead guilty to. So, yep, agreed facts. They also have to, they have to match the offence that you've pled guilty to. The agreed facts can't sort of be so weak that it looks like you've committed no crime. So otherwise the judge is not going to accept that. So both sides sign the agreed facts. And when I have a client who has need for an interpreter, if I've got time, I will ask an agency to please give this to a translator to translate from English into the other language. I really like doing that so that I then send or give the document by email to the prison if my client's in prison, or email to my client if they're on bail and have email access. So the client can read the agreed facts in their native language. But I don't always have time to do that in writing, get that done in writing. So I might, if I've got a chance and the interpreter has email address, I might have the interpreter on video or telephone in the video conference or at court or in the conference, and I might have the interpreter on the spot go through that document and read it and translate that into the other language so that the person knows in their native language what those agreed facts say. And I'll get them to sign the English version and the other language version, and I'll keep the other language version on my file so that I've got evidence that they did receive that in the other language. If I've got time, I might even have the same interpreter the same translator who has translated the document. I might have that person actually read out their translated document to the client in that language, and then the client hears it as well as seeing it written. So that's something I like to do. I definitely like to have that document put into the other language verbally and or in writing. So that's an agreed fact, and that goes to the court, and that is what the judge reads. So instead of a situation where the brief is 5,000 pages of documents originally, the agreed facts might be 3 pages, might be 10 pages. It's a summary of what happened and an agreed summary. So rather than have the judge read thousands of pages of documents, we just summarize it, and it saves so much time if the judge just reads an accurate agreed summary. Burden of proof is who must prove the case, who must prove the ingredients or the elements of the offence beyond a reasonable doubt, or on the balance of probabilities. Who has that onus? Who has that burden? In criminal law, the burden of proof rests with the prosecution. They are bringing the allegations to court. They are trying the person. They have the onus or the burden of proving each essential element or ingredient of the case, of the charge, beyond a reasonable doubt. So there shouldn't be any other reasonable, sensible, rational reason that this explanation, there can't be any other reasonable, rational, appropriate explanation for this happening except that the accused committed the crime, or the accused had this intention, or the accused did this. So by elements, it's like ingredients of, when you're cooking something, you might need to have, you're making a cake, for example, you might need to have eggs, you might need to have flour, you might need to have milk, you might need to have chocolate flavoring to make that particular cake, because without one of those ingredients, it's not going to be chocolate cake. It might be something different, but it's not going to be chocolate cake. So every crime, every offence has specific essential elements, and the prosecution must prove each and every element. So for a murder charge, a person, and in this case the accused person, caused the death of the deceased, that they intended to cause the death or to cause grievous bodily harm of the deceased. So the prosecution have to prove the accused did it, and not only did it, but they caused the death. So if there's another possible cause of death, like a long-standing illness that caused the death, if it can't be proven that the death was caused by anybody, then should be not guilty. If there's a question over who caused the death, then, and there's a reasonable doubt about who caused the death, then the accused should be found not guilty. If there's a doubt about whether the person is actually deceased, for example, because maybe there's been no body found or something like that, and maybe the suggestion is that the person is overseas somewhere and left and didn't get killed, then that if the jury don't feel that that's been proved beyond a reasonable doubt, then that would be not guilty. Or it might be the case of the person caused the death, but there was no intention to cause the death or grievous bodily harm. It might be more manslaughter rather than murder. It might be an accident, or it might be non-intentional cause of death, like one punch, or some other explanation. But that's something the prosecution have to prove beyond a reasonable doubt. If the test becomes balance of probabilities, if it's, example, the accused is not denying that they did something, but they're saying that they're not criminally responsible because of a mental health impairment or a cognitive impairment, then the onus or the burden of proof turns to the defence to say, well, here's the evidence. Here's this psychiatrist or psychologist or neuropsychologist saying this was my mental condition or cognitive impairment at the time. And at the time, because of that cognitive or mental impairment, I did not understand the nature and quality of what I was doing, or I did not understand that it was morally wrong to do that. And they raise that defence of impairment. That is balance of probabilities. So it's a less stringent or less strict test than beyond reasonable doubt. And civil cases and AVO, and we'll touch on the AVOs later. Civil cases and AVO or apprehended violence orders use balance of probabilities, more probable than not. It's not such a high, difficult test than beyond reasonable doubt. The problem is it's really hard to explain beyond reasonable doubt, and judges will tell the jury that beyond reasonable doubt is its ordinary English meaning and it doesn't need to be explained, which is really hard to explain because often juries will, anybody, whether it's a jury or anybody in English, it's hard to explain in English, let alone, I'm sure, let alone another language. It's really hard, but there has to be some really no other rational explanation for that. And because if there is a rational, reasonable explanation for something, it should be not guilty. The prosecution have failed to prove beyond a reasonable doubt. If there is some rational, reasonable doubt, that should be not guilty verdict. Objective seriousness is something you will hear in sentencing, local court, district court, Supreme Court. So if you're interpreting in a sentence proceedings, you will hear the term objective seriousness by the prosecutor, by the defence, and by the judge or the magistrate. It's looking at the facts of this case, how serious is this compared to other types of this example of crime. So let's look at a robbery, for example. There are many, many robberies, but some are more serious when you look at the facts of them than others. It's not to say that they're all serious, but because of the factors of some of them become even worse than others. So a robbery does involve a threat or a threat, but if it involves, it doesn't necessarily involve physical violence, but it certainly involves a threat. I'll hit you if you don't give me the money. That's a robbery. That's a threat of violence. But if it involves actual violence, then it's more serious than one that has a threat but no actual violence. So the actual violence makes it even more serious. The amount of property stolen may also make it much more serious than one where it's 2 cigarettes are stolen as opposed to $20,000 stolen. Objective seriousness might be higher where there is more than one person committing the robbery. It might be more serious where the person is injured in the robbery, hospitalized in the robbery. So certain factors make it much more serious, objectively serious. So looking at all the factors involved, the lawyers will make submissions about objective seriousness, looking at it compared to other crimes of that type. So that's something that's raised in sentencing. And if it's more objectively seriousness, you could expect perhaps a higher penalty than something that's less objectively serious. Precedent is like a prior case. Lawyers rely on precedents, judges rely on precedents, past cases, past examples. So we look for cases of similar charges or same charge, similar facts, precedents. We rely on precedents. You also have precedent documents as well. So a past example, a template, a precedent document. So something's happened in the past or been used in the past. There is a precedent for it, there's an example for it, or a case may create a precedent. It might be new law, it might be brand new example of this. Something may not have happened before of this type, and then it may set a precedent. It may set the example, so then it may be copied or relied on or used in the future.
Thanks, Helen. I don't think we've got any questions for this section, but we might have a break now. It's just coming up to 12. we'll probably have 10 minutes just to give people a chance to stretch their
Absolutely.
legs, and for you especially to have a break. So we'll come back at 12:10. And if you've got any questions in the meantime, feel free to put them in the chat. And Cinzia and I are just working out the best way to send the slides, copy of the slides and the tips for interpreting in court. So sorry about that. Bear with us on that. And we'll see you back at 12:10. Thanks, Helen.
Thank you.
Thank you, everyone. Hi, everyone. We're going to come back in a second. I think we're just going to have to email people the slides if you want them, the slides and our tip sheet afterwards. We're not able to attach it to this Teams meeting, sorry. All right, so I just wanted to also say that we will finish at 1 o'clock. I think that was the time we had in the Eventbrite invite. So we'll finish at 1 p.m. So we'll go straight through to then. There's still quite a lot to go through. So I'll hand back to Helen. If you do need to leave early, that's fine. You should still be able to access the recording for anything you've missed. But otherwise, yeah, stay with us till 1 o'clock. And thank you very much. Keep putting your questions in the chat or put your hand up. Thank you.
So legal document words, we have court attendance notice, or CAN, as it's often referred to. This is a document produced by police when somebody is charged. A court attendance notice is produced and it states what the charge is. And so you have the police fact sheet and a court attendance notice specifying the words of the charge, whatever charge that is. Affidavit is a document which doesn't just exist in criminal law, exists in other jurisdictions as well, and it is evidence. It's written evidence which is sworn on oath or affirmed, and any person can make one. Lawyers do it. I have to do these a lot for different court applications. Clients do them. Very common. It's a way of putting evidence before the court in writing. And the deponent is the person that makes the affidavit, the person who swears or affirms that the contents of that are true, that it's the truth. And it's basically setting out facts, but I also use them, for example, sometimes I've got a client that's being sentenced and I might want the client to give some evidence in that format in writing. So client will talk and I'll type and then I witness their signature on it. And it's a form of evidence. So if that gets tendered without objection by the prosecution, it's evidence and it's factual. So other times where I need to make an affidavit is when I'm applying for some court orders through making a notice of motion. So I produce a document called a notice of motion, which is about a one-page document, and that is making a motion or literally asking the court for orders. For example, can you please separate the trials? Can we have a separate trial to our co-accused? Can we separate the charges which are on that one-page indictment? Can we have a separate trial for charges 1, 2, and 3, and a separate trial for charges 4, 5, and 6, separate trials? So I'm seeking court orders, and I have to create the document, the notice of motion, specifying what orders I'm actually seeking so the judge can see straight away what I'm actually asking for. And the affidavit is more why I'm asking for that, sets out facts. And I might have to annex or attach various documents to support my application. So affidavits about facts, I try to keep mine as chronological as possible. So it tells a story in logical, chronological order. But affidavits can be used in many ways. But it becomes evidence, and it's a crime to make a false statement once, because you're affirming or you're on oath saying it's true and correct to the best of your knowledge that it's correct. So it's a crime to swear or affirm a false affidavit knowing that it's false. And a statutory declaration, we use these in everyday life a lot. When you fly back to Australia and you're filling out the document that customs or customs give you about what items you're bringing into the country or not bringing into the country, and you're ticking yes or no. I have plants, I have food, or etc. That's a statutory declaration that what you're saying is the truth, and you can be prosecuted if you make a false declaration. So you're signing it and you're declaring that that is the truth. So statutory declarations are used on passport applications as well. Lots and lots of documents. Subpoena is a document produced, and it's an order of the court, becomes an order of the court. You file it at court, and I might issue a subpoena for a witness to attend court, so that I take the document to the court registry asking that Natalie attend court on the 2nd of March, and it says that there'll be a warrant. A warrant may issue for arrest if this person fails to appear at court. Or I might take a subpoena to court, draft a subpoena requesting specific documents to be produced at the court registry on a certain date. So I might subpoena police or the hospital or a counsellor or various other organisations. I might issue a subpoena for production of certain documents, and I have to specify what documents I'm asking for. That's a subpoena for production or a subpoena to give evidence. And once I take that to court, the court orders it. It becomes a court order that it's the court ordering those documents. So the court can issue a warrant for arrest if those subpoena is not complied with. Oath or affirmation, so you're swearing or you're affirming on the affidavit or the statutory declaration that the contents are true and correct, and that you've told the truth. And a juror gives an oath or an affirmation that they are judging the evidence, judging the case according to the evidence. They make a promise to the court that they are being faithful to the evidence. When you go to interpret in court, you are under oath or affirmation to interpret to the best of your ability, being accurate and faithful. So you're making a promise to the court, oath or affirmation. When any witness gives evidence, they are making an oath or affirmation to tell the truth to the court, a promise to tell the truth. Oath is a religious, whichever religion, it's a religious promise to God or the religious being to tell the truth. And an affirmation is a promise to the court to tell the truth. They are given equal weight. It doesn't matter if somebody's religious or not. It doesn't matter what religion they are either. Or it doesn't matter if they're no religion. So affirmations are promised to the court to tell the truth, but both are of equal weight, and it's a crime to lie on oath or affirmation. People can be charged with perjury, punished for that. Warrant is a warrant can be issued by the judge or magistrate, by the court for arrest. They can also be issued by parole authority to arrest somebody, and for police to go and arrest somebody. So a warrant can be issued for breach of bail, for failing to appear in court, failing to turn up when subpoenaed to do so, a warrant for breach of bail, all sorts of things, warrant for arrest. So then the warrant is issued by the particular authority, and then the police can go and execute that warrant, locate the person, execute the warrant, bring them before the court to answer the allegation of, the fail to appear in court, the breach of the court order, that sort of thing. Next slide. Yep. So offences against the person. So murder, manslaughter. Murder is the most serious charge, carries life imprisonment, and life means life. It means if a person is given life imprisonment, there is no prospect of release. They will die in jail. There's no non-parole period. There's no minimum time in New South Wales. Different states do it differently. Some people are on parole for the rest of their life, but they will be released but remain on parole. But New South Wales, a sentence of life imprisonment, there's no parole. There's no release on parole. It means a person will die in jail. And murder is about intention to kill or to cause grievous bodily harm. Manslaughter is an unlawful killing, but it's not an intention to kill or cause grievous bodily harm. The maximum penalty is still a lot. It's 25 years in jail, but the difference is the intention or lack of intention to kill or cause grievous bodily harm. So both of those are about death has been caused, but the intention is what is different. And that is why manslaughter is considered less serious than murder, because there is not the intention to cause the death. It might be an accident, it might be excessive self-defense, or it might be unlawful and dangerous act like a punch is unlawful, or a stab wound to the arm which causes an artery to be cut and bleed out. Maybe it's unlawful to do that stabbing, but it may be that it wasn't intending to cause the death. So it's kind of unintentional or more accidental that the death was caused, but though the stab wound itself was deliberate. Common assault carries a 2-year maximum penalty, and it is the least serious of the offences against a person, but it certainly can range in seriousness, and that's where on sentence the objective seriousness, what was the actual injury, what was the actual harm caused, what were the circumstances. So common assault can range from no physical contact at all, but a threat to do it. Can be spitting, can be physical contact, but actual bodily harm, so an assault occasioning actual bodily harm, is more serious than a common assault. So actual bodily harm may be a bruise, a red mark, a scratch, might be a cut, but it may be less serious than, it's certainly less serious than grievous bodily harm or some sort of a deep wound. Technically, a wound is a breaking of the skin, but prosecution may agree for it to be actual bodily harm, not a wound. So there's different levels of wounding as well. Grievous bodily harm is really serious injury. That's what it means. That's what the jury is told it means, really serious injury. But it may not necessarily be permanent injury. The person may heal from it, but it is grievous bodily harm is considered, it's much more serious than actual bodily harm. It's much more serious than common assault. But grievous bodily harm is not resulting in death. So that's why, so it is different to manslaughter or murder. Manslaughter or murder has the result of the injury is death. A fray carries a 10-year maximum penalty, can be dealt with in the local court or can be dealt with in the district court. 2 or more persons in effect have some kind of a fight. There doesn't have to be anyone else around, but if there was, what they were doing had potential to put anybody, a reasonable person, in fear of harm. So lots of affrays are in the community, in public and big group brawls. A lot of them are, but at law it doesn't even have to be that bad. It it can be two people having a fight, which if somebody else had seen it could have been fearful or apprehensive that, you know, this might have caused them some harm or some injury. Brawl, there's no actual crime called a brawl, but a brawl really is some kind of a skirmish or a fight, may be with or without weapons. And a fray may or may not have any weapons either. But again, objective seriousness, if there's weapons involved, you would think it would be considered more serious than an affray where it's punching with fists where no weapons are involved. And you might look at the number of people involved, injuries sustained, that sort of thing. And then we get to sexual offences.
Helen, there's just a question about life sentences and without the possibility of parole.
Yep, so life sentence means life. Yep, that person will be in prison for life. In the consecutive means, that's certainly something I think comes up in US law. They can add on. So, or a sentence is consecutive if it is tacked on to the end of the other sentence. It's consecutive, not cumulative, not partially cumulative, that sort of thing, not overlapping, not
concurrent.
Not concurrent, the word I'm looking for. Not concurrent. So some sentences overlap and they're partially concurrent, partially cumulative. And if there's a situation where there's 5 life sentences, that would mean that there would be, I'd assume there would be 5 victims involved, 5 deaths to get that sort of sentence, because you wouldn't get that for one person, one charge of murder where there's one victim. And no, without possibility of parole means the person will die in prison. They're not going to ever be released in the community on parole. Sexual offences, so a lot of trials in district court are sexual offences, and you indeed might be called to interpret in a sexual offence hearing or trial or sentence. The legislation, the Crimes Act 1900 in New South Wales, has undergone many, many changes over the years, over the century, because it did commence in 1900. So language has changed as well. The language of the charges has changed, and also charges have changed depending on community attitudes. So it used to be the case where homosexual relationships were, in some states or some states, were illegal, so there would be crimes against that. But now homosexual relationships are not illegal in New South Wales, so those crimes have been, if it's consensual, then it's not a crime. If it's not consensual, if any sexual offence involves lack of agreement, lack of consent, then it is a crime, because there has to be consent for it to be legal. Sexual assault, the old term may have been rape, but sexual assault is a broader, wider definition than rape. In the past, rape used to really only involve prosecution of male accused with a female alleged victim. It was considered, in the past, it wouldn't be considered that a female could rape a female or a female could rape a male. Sexual assault is broader, so that you can have females accused of sexual assault, you can have males accused of sexual assault, non-binary genders accused of sexual assault, and alleged victims can be male or female or identifying or not identifying as any gender. Sexual assault is broader. It protects, in a sense, it protects everyone as anyone that's, you know, an alleged victim, saying that they were sexually assaulted without, you know, something happened to them without their agreement, without their consent, can go to the police and there would be a charge able to be laid. But in the past, not everybody was protected by the sexual assault or rape crimes or charges available to police to charge people with. And sexual assault doesn't just cover the penetration, okay, of body parts, one body part to another. Sexual assault also involves situations where somebody is accused of using some sort of an object to penetrate the body part, the genital area of somebody else. So it's not just person, and it's not just penile vaginal penetration. It also involves what's called digital penetration, somebody inserting finger or fingers. It also, and it's not just penile vagina, it also includes the mouth, somebody inserting something without consent into the mouth of somebody, or the anus of somebody. So it's much broader than it used to be. It's much broader legislation than rape. But sexual assault involves penetration of an object or a body part to the genital area of another person's to the genital area of another person. So sexual assault's much broader. Sexual touching previously has been called indecent assault. So sexual touching is not penetration of by one person to another person's genital areas. Sexual touching is unwanted, non-consensual touching, or, you know, of a person's genital areas, or it might be a female breast, might be somebody's backside, might be the outside of somebody's underwear, might be sexual touching of a male's genitals with or without underwear. It might be the sexual touching of a female's outside of the genitals, either with or without underwear. It's non-consensual, unwanted, non-permitted touching by one person of another, but no penetration. That's the difference between sexual assault and sexual touching, the penetration aspect, but both are non-consensual, not wanted. I should just say that at law, a person under 16 cannot consent to this. So at law, a person under the age of 16 cannot legally give consent. A person above the age of 16 can legally give consent. And again, the law's changed in that there used to be different ages of consent for males and females. So that's something interesting that's been changed over the years. Now, both genders, all genders, age of consent is 16. Anyone under 16 at law cannot consent. So sexual act, previously called an act of indecency. An example of a sexual act might be somebody who is exposing their genitals in public, or exposing their genitals to somebody in the home without consent, exposing themselves, or masturbating in public, or masturbating without consent to somebody. That's a sexual act. Or it might be inciting or telling somebody to do a sexual act so that person the accused watches that action that they've commanded or demanded or told. So that's a sexual act, or telling somebody to perform a sexual act, that sort of thing. So again, there's this lack of consent involved, implicit in that. Sexual harassment is not a crime, but it can be part of the anti-discrimination legislation. So, and workplace sexual harassment policies in place, but there's not actually a crime to sexually harass, but certainly civil proceedings may take place, or the tribunals and things like that for that. Child protection register. So if somebody has been convicted of an offence, a sexual offence against a child, then they are placed on a register, and there are prohibitions and restrictions and rules in place. For example, and they're monitored by police. For example, they may not be able to have a phone with internet. They may have to declare all internet devices, phones, laptops, iPads, computers, phone numbers, SIM cards, all of that. So there'll be a list of restrictions. They may not be able to live a certain distance from a school, all those sorts of things. So that's a child protection register. And they can be national, and they can be or state-based, imposed in one state and cover the whole country, etc. So consent, I've touched on this. Consent's an agreement. It's permission. Consent, but person under 16 is considered not able to give consent. There are recent changes to consent laws in the Crimes Act, and a person cannot give consent if they are so intoxicated, and the trial might be about level of intoxication, whether the person was even capable of giving consent. A person is not considered capable of giving consent if they are unconscious because they're sleeping, or unconscious because they have been given or taken drugs or so much alcohol. So if they've passed out and they're unconscious through either voluntary or involuntary consumption of a substance, some people are given what's called those rape drugs. Okay, rape drugs, some sort of a chemical or a substance. Their drink might be spiked, or their food might be spiked, unknown to them, and then they are rendered unconscious or unable to move, and that would be considered they're unable to consent if they're in that state. So consent, that would be a sexual assault if the person if sexual touching or intercourse happens while a person is in that unconscious for whatever reason. Aggravated, a crime might be aggravated for multiple reasons. For example, more than one accused. It's called in company, so that would be a sexual act done in company, meaning more than one accused, would aggravate the offence, make it more serious with a higher maximum penalty. Something might be aggravated because of the complainant's cognitive impairment. They might have a cognitive or intellectual impairment, and that might be known to the offender or the accused, and that aggravates it. It might be aggravated because of the level of intoxication. So various reasons why something might be aggravated, or it might be aggravated because the person is under 16, under the age of consent. Aggravated. Whether a person knows somebody is under the age of 16 might be a defence to a charge. The person may honestly and reasonably believe that a person was in fact 16 or above, and consenting, and that might be the defence at law. And there might be reasons for why they believe that. Example, person might have stated their age and said, I'm 18, I'm 19. They might have put things on social media with a different age. They might have had a fake ID, all sorts of things. They might have, you know, there might be reason for believing that a person is above the age of consent and actually consenting, and that might be the evidence at trial. So that's age. I've touched on age of consent. Historical sexual abuse are matters that happened some time ago, and they may not be charged with those offences for quite some years. So with the Royal Commission, people have been encouraged certainly to come forward and lay allegations. So we have a lot of cases coming through court which are 50 years old, 40 years old, happened in the 1970s, 1980s, which are being prosecuted now, a long time ago. And we have to go back at the Crimes Act, the historical versions of the Crimes Act as well, and look at what offences were in force at that time, because the law has changed so many times as well. So the charges have different wordings, different things were or were not law at that time. So that's historical sexual abuse or historical sexual assaults, old offences. Property offences. So theft or steal from person. So theft, larceny. If you look at the Crimes Act, there's many, many types of larceny. Larceny by a clerk, stealing, shoplifting, different levels, you know, might be different under or over a certain amount, different levels, and the amount might dictate the penalty, or it might dictate which court it ends up in. Less than $60,000, more than $60,000, it might result in it going to a different court. Larceny carries a maximum penalty of 5 years in prison, and whether or not the maximum is given will really depend on what and how much, the value and things like that. Steal from person is a charge which carries a maximum penalty of 14 years in prison, and the difference between it and robbery, which also carries 14-year maximum, is with robbery there's a threat involved, verbal or physical threat. There's a threat involved with a robbery. Both involve a stealing. And steal from person, a classic example is a bag snatch. You're on the street and somebody snatches your bag. That's a steal from person. That's a classic steal from person. Both robbery and steal from person can be dealt with in the local court. The local court has a maximum penalty allowance of 2 years in prison, but if it's dealt with in the district court judge can go higher than that 2-year limit. But local court magistrate is limited to a maximum of 2 years in prison. Prosecution can elect to take those charges up to district court, and they might do that because the person may have a very lengthy criminal history, or they may have committed the offence while on bail or while on parole, and the prosecution wants to try and get them a harsher penalty than what the magistrate in the local court can give. Shoplifting, usually dealt with in the local court. I've touched on robbery. There's a threat, there's a stealing, there's a threat, and there's a theft and a stealing, and there's a threat involved. Robbery in companies, more than one person is involved in the robbery. Burglary, I think that's more used in other jurisdictions, and I think in Queensland, I might be wrong, but it's usually nighttime. There's some distinction between whether it's day or night, but that's not used in New South Wales. Break, enter and steal can be any time of day in New South Wales. There's a break-in. It doesn't have to be doesn't have to be damage for there to be a break. It doesn't mean that the glass of the house, of the window is broken, but it might be that the window is unlocked and opened. moved, the door is pushed open further, the sliding glass door was unlocked but it's opened and the person's entered, that still constitutes a break. Be more serious if the person has damaged the property to get inside. Break, enter and steal. You can also break and enter and commit another really serious offence, like sexual assault, things like that. So depending on how serious the offence or how much was taken, things like that, then the penalty may be worse. So that comes back to that objective seriousness of the offence, depends what actually happened once the offence has occurred. Fraud, various types of fraud, credit card fraud, identity fraud, identity theft, they're sort of dishonesty offences, and various types of penalties depending on the type of fraud. So frauds can also be Commonwealth prosecuted as well. Centrelink is Commonwealth prosecuted by the Commonwealth Department, Director of Public Prosecutions. Tax fraud, Commonwealth prosecution. Obtain benefit by deception. It might be pretending to be somebody else and using their credit card to buy things. It might be using a false identification to get some kind of a benefit, to pretending to be somebody else to get some kind of a benefit, whether that's opening a bank account in that person's name, stealing, getting some kind of a government grant in somebody else's name, lying about whether you are working or not, but still claiming the Centrelink benefit. That might be considered, obtaining a benefit by deception, by lying. Trespass is entering onto a property and not leaving when you're requested, or not supposed to be there, have no lawful reason for being there. Trespass alone has a fine. It's not jail. Entering closed lands, it's a fine. It's not a jail offence. Sometimes it comes with another sort of offence. So there might be a trespass and doing something else while on that property. But trespass itself does not carry jail. Drugs and alcohol. So illicit drug is illegal. It's an unprescribed drug as well. It's illegal to be in possession of that. It might be an illegal drug because it's cocaine, cannabis, etc. Possession of the drug is illegal. I think that there are talks about reforming drug laws. Possession of drug is 2-year maximum penalty and can be dealt with in the local court. Drug use is not actually illegal. There's no crime of using drugs, but there is crime of possessing drugs, or possession of drugs, or possession of prescribed medications which are not in your name is also illegal. Supply or deemed supply. So if you are in possession of supplying a drug, then if you're holding over a certain quantity, or if it's in your home and in your room and you hold the keys to your room and you control your room and you're in possession of that drug over a certain threshold, over a certain quantity, you might be accused of deemed supply. Police don't think you could possibly be using that drug for your own personal use, and they might find some other evidence like scales to weigh drugs, plastic bags to put drugs in, book or notes with who owes you money for certain previous supplies of drugs. So there might be some other evidence suggesting that you are running a supply drug business, that sort of thing, or not. There may not be that evidence, and maybe you admit you possessed it and that it's for personal use, not for supply, and you're not guilty of supplying, but you're guilty of possession. Supply can also be sharing drugs at a party. You may not make money from it, but the act of sharing is a supply, but objectively serious objectively less serious to do that than to make a profit or make money out of it. So that comes back to objective seriousness. But sharing drugs is still a supply of drugs at law. Merit program is a kind of diversionary program in the local court. Go away, complete this program, come back, and the chance of staying out of jail will be higher than if you fail to do the program and keep offending, etc. So it's a kind of diversionary program, magistrates early referral intervention. Can't remember what the T stands for, but it's magistrate refers you to go and do this program, go and complete the course, come back, and then get sentenced.
Into
Early
treatment,
treatment, yeah, so it might be drugs or alcohol treatment. Go away, go and get your treatment, and come back and get sentenced. Driving offences, driving under the influence of alcohol or drugs, is a crime, carries different penalties depending on the level of drug or alcohol, depending on the level of alcohol, low range, mid range, high range, depending on how many times and how frequently, like last 5 years, how many offences, that sort of thing. So high range offence, that high range alcohol which causes an accident, somebody dies, you are facing jail for that. Multiple offences within 5 years, your risk of going to jail is higher. Disqualification periods, fines, interlock program, not being able to get in the car and drive with any alcohol in your system is a punishment, is part of a punishment as well, part of an intervention to stop somebody drinking and driving again. So, yep, driving under the influence of drug or alcohol is a crime and it is punished at law.
Thanks, Helen. Look, I'm just looking at the time. I think it has been a long morning, so we probably should try and wrap up just on one. Maybe the next slide was about domestic violence, so that kind of in between civil law and criminal law. So like Helen was saying, the AVOs or apprehended violence orders are not actually a criminal charge. They are civil matter. So I might just skip through those unless anyone has a particular question about AVOs. I know they are a very common thing you might be in court to interpret for. So if you've got any particular of those terms that you want explained, maybe put that in the chat. Otherwise, I think we might just move on. And Helen, I think the slides coming up around sentencing,
Yep.
and we've already talked quite a bit about spent quite a bit of time on the non-parole period and that kind of thing.
Yes.
So maybe just have a quick look at the slides and we can skip some if we've already talked about that. I did just want to say that the line at the bottom of that slide there, coercive control. So there's going to be new laws in New South Wales to criminalise coercive controls as a form of domestic violence between intimate partners. So that's something that we will have some more webinars and that kind of thing on coming up. So if you subscribe to our newsletter, and I can put the link in the chat, you'll be able to find out more about what's coming up there. So yeah, I won't go into that because I think maybe these are kind of common terms for you maybe already, or if you want anything explained, please put it in the chat. Otherwise, I think we might just move quite quickly through. The other thing we probably don't have time to do is around the mental health terms. Helen, that might just take a bit of time. So I think just quickly cover off on the correctional or conditional release orders, that kind of thing that people might hear.
Absolutely.
What they are. And otherwise, I think we probably need to, move pretty quickly for the last 5 minutes. Sorry, everyone. Thank you. Thanks, Jinzia. Was there anything on that next slide, Helen, the table or?
I didn't see it, sorry. So discounts on sentence are available depending on the time that a person pleads guilty. If a person whose matter is going to go to district court or Supreme Court, if they plead guilty in the local court, they are given advice. They have to be given legal advice about this. So you may have to interpret this in a conference. If their lawyer is doing the job properly, that if they plead guilty in the local court, they are eligible for a 25% discount off the sentence. And when they are sentenced, the judge will refer to the timing of the plea of guilty and the discount that they are given. If they plead guilty later, if they've originally pled not guilty in the local court and been committed to the higher court for trial, then they change their mind and they decide to plead guilty, then as long as they plead guilty more than 2 weeks before the trial date, the commencement date of the trial, they're eligible for a 10% discount off the sentence. But if they plead guilty less than 2 weeks before the trial, or 10 days, like 2 weeks, 10 days. 2 weeks is like a court week is 5 days, so 2 weeks, but 14 days, if less than 14 days before the trial, or worse, on the day of the trial, then only eligible for a 5% discount off sentence. So the earlier you plea, earliest is local court, later you do, that discount starts diminishing. Next slide, please. There's a whole range of punishments, and they range from fine to Section 10 capital A down the bottom there. It's a conviction but no other penalty. So you're not fined, you're not given any jail time, it's just convicted, that's it. Section 10 brackets 1 brackets A, charges dismissed and without conviction. So that can often happen if it's the very first offence that somebody's ever come to court for, and it's not so serious. So somebody, and no conviction can be very important for a person's job or wanting to travel and things like that. So dismissed, no conviction. Court fines, yep, people can get a fine. More common in the local court than the higher court because the local court deal with less serious matters usually. Conditional release order is a non-jail sentence. It's served in the community, and it's considered for less serious offences. I hardly see these in the district court, more common for local court. Community correction order, non-jail sentence, again, it's like, these two are like a good behaviour bond. Be of good behaviour for a period of time, don't commit any new offences, follow the rules. You might have some rules like go to the doctor, get your treatment, depends what the situation is or was. Might be go be supervised by community corrections or not. It might be don't drink any alcohol, depending on what the situation is. There might be some conditions involved. If you don't follow those conditions, then you may be charged with breaching that and have to come back to court and be re-sentenced. An intensive correction order is a jail sentence, abbreviated to ICO. It is a jail sentence. However, it is a jail sentence which is served in the community under supervision by community corrections or the parole office. And there are conditions. Supervision is one, be of good behaviour, and whatever other condition the judge wants to give, which can be a whole range of conditions. Treatment, no alcohol, no drugs, curfew maybe home detention, maybe up to the judge or the magistrate. And full-time prison's the worst that you can get. And I've already explained the structure of sentences. I've gone into this, but you may hear special circumstances, and it allows, it might be reasons where the judge adjusts the sentence, adjusts the length of the non-parole period, adjusts and lengthens the time under supervision on parole. Old people, young people, people with mental health issues, a whole variety of reasons might allow the judge to do that. Mental health, big part of the criminal law. We have a lot of people, unfortunately, overrepresented in custody who have mental health issues. It's sad. They don't always get the treatment that they need in jail either. So few psychiatrists visiting or seeing people, and so many people on the waiting list. Fitness hearings is when somebody's unwell to understand the procedures, can't really instruct their lawyer properly. Psychiatrists give a view, they give an opinion that this person's unfit. It's not just the client saying they're not fit. It has to be tested by a psychiatrist or a psychologist if it's an intellectual impairment. Special hearing is like a trial, but there's no jury and it's with a judge only. And they look at the evidence and decide guilty or not guilty, or not criminally responsible because of these impairments, mental or cognitive. Community treatment order is made by a mental health team. It might be ordered by the mental health review tribunal to get treatment in the community by the local area mental health team. And there'll be conditions: take your medication, come and see us every week, every month, that sort of thing, monitored. Section 14 is in the local court under the mental health legislation to discharge. It's not a guilty or not guilty finding. It's to divert the charge, dismiss it, discharge it under, go and get treatment. Have a treatment plan in place by a professional. The court will deal with you under that legislation as long as you go and get treatment. So not guilty on the grounds of mental illness is the old term. Now it's not criminally responsible, or act proven but not criminally responsible. So you did the act, did the offence, but you're not criminally responsible because of, at the time, your cognitive impairment or mental impairment was impacting on your thinking and your ability to know what you were doing was wrong, morally wrong, or know the nature and quality of what you were doing. And this needs to be proven on the balance of probabilities, and expert reports need to be provided saying these are the conditions, these are the health issues, the mental health, cognitive health issues, and in the expert's opinion, this person was so affected by that condition that they were unable to decide what they were doing was morally wrong, or didn't know the nature and quality of what they were doing. So as an interpreter, you may have to give evidence, you may have to interpret in those proceedings as well, and it's a big part of criminal law as well. Or you might interpret at the tribunal, the Mental Health Review Tribunal.
Thanks, Helen. We're just a bit over 1 o'clock, but we are nearly finished. So the next slide, Chinzia, if you move, that was just the American words one.
Yeah, so misdemeanor, I think it is like summary offence. I think we don't use first or second degree murder. I'm not 100% sure what that means in American law, but we don't use that. And we don't have early release for good behaviour. That minimum non-parole period is the time you must do. If you are not good in jail, then you may receive extra punishments, or you are at risk of not getting released on parole when your time comes to be released. You're at the risk of that if you have, example, been getting in fights and everything. So we don't have early release for good behaviour. Plea bargain, sometimes it is used here, but that's not really the correct term here. Negotiations, representations, case conference, but we don't actually use plea bargain. We don't consider ourselves bargaining anything. You do enter a plea, but we don't officially use plea bargain.
All right. Well, thank you very much, Helen. I think that's pretty much the end. This is about the, let me just quickly put the link in the chat for how you can sign up to our alert. So that's if you want to join us for other webinars, so not only about legal words, but about anything, you're welcome to join our webinars. We have lots of interpreters joining. So I'm just going to put this in the chat. So if you click on that link, you can, there's this button to subscribe to our alert. So that's probably a good way to keep in touch about what we're doing next. We will be doing some of these legal words for interpreters with family law words and also civil law words, like Helen mentioned, you might interpret in tribunals. So we'll talk more. I think we did one last year with our mental health advocacy service. So we'll try and do one of those again this year. Yes, so have a look at that link, and I think that's all for today. So thank you very much, Helen. I know it's been a long morning for you.
No, that's right.
Everyone.
Thank you to everybody for listening, and thanks for all the questions. And thank you, Natalie and Jinzia, for your assistance with the slides and everything. Because I can't multitask that well to have to do the slides and talk about them. So
No,
thank
it's
you.
perfect. So we will send an email to everyone with the links to the resources and the slides, and also a survey, which you can give us your feedback on the session through that survey link. So thank you again, everyone, for joining us this morning. Have a great rest of the day. If you do have any last minute questions, I'll hang around for a few minutes.
Same.
Yeah, but thank you, everyone.
And feedback's important. So
yeah,
please give us your feedback, because we do read it, and we do want to, make any improvements and things like that. So positive and negative, constructive criticism, all welcome. Thank you.
All right. Thanks, everyone.